Hello and welcome. Did you know out of the 24,000 speeding tickets that are argued in court every year, over 10,000 drivers actually win their case? According to the RAC's research, over 400,000 speeding tickets issued are successfully challenged before they even reach court. There are 5 successful legal arguments you can use to defend your rights and beat the fines. In this video, I'm going to give you all 5 defences, including a last resort option at the end, which, if you're facing a ban, might just open the door for a better chance of not losing your licence. We do need to clear up a massive misconception. Now, if you type into the YouTube search bar speeding tickets or speeding fines or how to beat a speeding offence, it will bring up lots of channels. But what it will also do is bring up a lot of American channels explaining how you can argue and defend your speeding fines. Now, there's only one problem with that. The arguments and defences you can use in the United States don't apply in the UK. So if you're watching those channels and you get a court and you try and argue some of the reasons that they use, you'll have no chance whatsoever of winning. In the United States, you might be able to argue that you were keeping up with the flow of the traffic, or you were being pressurised by a car behind you, or you had to get to an urgent appointment, or maybe even sweet talk your way out of a ticket based on the time of day and how empty the roads might be. In the UK, however, speeding is what they call a strict liability offence. That means your intentions, your reasons, and any excuse you can think of really don't matter from a legal perspective, and magistrates aren't going to want to hear it. Fundamentally, if your car crossed that speed limit and triggered the camera, you're legally liable. And what makes it worse, because it's a strict liability offence, your options for a defence and legal argument are very restricted compared to the likes of America and some other countries. The magistrates hear the same excuses every day, and they will shut you down immediately. Excuse number 1. I didn't realise how fast I was going. Ignorance is not a defence. It's your legal responsibility to know the speed of the vehicle that you're in control of. And then excuse number 2. The road was empty. There wasn't any traffic around. It was late at night. I was late for work. The court really aren't interested in your time management skills, and they certainly don't want to hear that as an excuse to try and wriggle out of a speeding ticket. In fact, if you walk into an English court with those excuses, you may as well have just paid the fine, because it's going to work out cheaper in the long run. You don't beat a speeding ticket in the UK by arguing about why you were speeding. You beat it by disputing their procedures, by disputing their technology, and proving you're innocent. So let's start with the first of the 5 valid arguments you could use. Again, this is a general statement, not legal advice. If you've actually had a speeding ticket and you want to argue it yourself, by all means go ahead and do it, but it's always wise to consult a solicitor as opposed to going in and arguing it on your own. So, argument number 1. Procedural time limits. The state must play by its own rules. Our first argument targets procedure. According to Section 1 of the Road Traffic Offenders Act 1988, the police have 14 days to serve a Notice of Intended Prosecution to the registered keeper of the vehicle in question. The key legal term here is served. If the police post it late, or administrative backlogs delay it, or if there's a postal strike, or for any other reason that's out of your control, it arrives on day 15 or later, the prosecution is fundamentally invalid, because it wasn't served and received by you within 14 days. So you request a dismissal based on procedural grounds. There is a caveat: the police do only have to use reasonable diligence to find you. So if you moved house and failed to update your V5C or notify the DVLA, the courts won't accept that as a reason. That's your responsibility and your error. But if the paperwork's in order, and the state was simply too slow posting the ticket out, or got held up in the post, or for whatever other reason you didn't receive it within 14 days, then that ticket in theory is time barred. So don't simply blindly pay the fine. Check the delivery date, check the date of the offence, and work it out for yourself. Obviously, if you want irrefutable proof, when it gets to day 14 after the offence was committed, not counting the first day, if you still haven't received it through the post, which you could mark on your calendar or set a reminder for, keep an ear out for the postman and try and get a photograph of the postman with the letter, or at least the letter in your postbox. And always check the postmark to see what date's on that. Moving on, argument number 2. Defective signage. There has to be fair warning of the presence of a camera and the speed limit. If a local authority fails to maintain the signage, or if they are entirely obscured by foliage or bushes or branches, or they're twisted out of view by being damaged, or covered in graffiti, again, the ticket wouldn't be enforceable. The state relies on you assuming that they've done their job properly. Don't make that assumption. If you're caught on a speed camera, return to the scene at your earliest convenience and document the environment around with photographs if you feel that that speed camera or the signage wasn't sufficient for you to be able to know it's there. Then you can show the court exactly what you saw from the driver's perspective. Obviously do it safely if it's on a busy road. Next we have argument 3. This is a classic. I wasn't driving the car. Which in fairness you may not have been. So why should you pay a speeding ticket if you weren't the driver? However, you have to be way up to section 172 trap. It does require extreme caution. This is where people can inadvertently commit a fairly serious crime. When you receive a Notice of Intended Prosecution for a speeding ticket, it includes a section 172 notice under the Road Traffic Act 1988. This demands that you identify the driver, and you are legally obliged to identify who is driving, if you know of course. So if it wasn't you, tell them who it was, and don't guess either, and obviously never nominate someone else to take your points. It is a lovely gesture if your spouse or your partner or your friend or your mate from work who's got a squeaky clean licence and never really drives offers to take your points, but don't be tempted to say yes, because that's perverting the course of justice. And believe it or not, 50% of people caught perverting the course of justice get an immediate prison sentence for it. Now no speeding ticket's worth that, is it? And the rest generally get suspended sentences as well. So if you genuinely don't know who was driving, perhaps it's a shared family car or a company pool vehicle, or you can prove unequivocally that you were somewhere else at the time the car was snap speeding, then of course you can mount a reasonable diligence defence. You must be able to prove to the magistrates that you've exhausted every avenue trying to track down who the driver was, and you just can't pinpoint who was driving the car at the time. As a registered keeper, that is your responsibility. So you could take evidence of phone records, text messages, statements from anybody else who has access to the car, anything that could corroborate your story that you don't know who was driving it, and that you've done everything within your power to try and identify who the driver was, but you can't. Okay, argument 4, medical emergencies. In this we'll look at duress and special reasons. So what if you knew you were speeding, the camera was working perfectly, but you had absolutely no choice whatsoever? A lot of people will say, my wife was in labour, I had to get her to the hospital urgently. Can I use duress of circumstances as my defence for the ticket? The answer is yes, you can use duress of circumstances for the ticket, but you would have to use the right legal path, and there are 2 distinct routes here. Duress of circumstances is a complete legal defence, so if you're successful, you'll be found not guilty. But the bar for that is exceptionally high. To win on those grounds, you would have to prove beyond a reasonable doubt that there was an immediate, life-threatening peril of death or serious injury, and that any other sober, reasonably minded person would have done exactly what you did in the same situation, because there was absolutely no other alternative. So, normal labour and many other medical emergencies simply won't be enough unless there is severe, sudden, life-threatening complications. Then you may indeed have a chance. So trying to argue duress of circumstances and achieve a not guilty verdict is highly unlikely in most circumstances. So just what do you do for a standard medical emergency? Things like rushing a pregnant pilot to hospital, or taking a child that's ill from possibly a severe allergic reaction to something to hospital, or something else that you would deem as worthy of exceeding the speed limit, but the magistrates may not. In those circumstances, you use special reasons as an argument for why you were speeding. You acknowledge that you were speeding, you admit the offence, and you use those special reasons as mitigating factors. But you must present some sort of medical records or other statements or proof to the magistrates to back up your story. If the court accepts your special reasons, they do have discretionary power to endorse your driver's licence with 0 penalty points and not issue a fine. So technically you did get a conviction because you pled guilty, but in certain circumstances you may walk away without any penalty points and without a fine, if you can prove you had special reasons for the speeding. Okay, on to number 5. This is the last option, but in fairness, this is the cherry on top of the cake. This is the argument and defence the system really doesn't want you to know about. System glitches and technological failures. Obviously, we must maintain healthy scepticism about modern automated policing. The police treat their cameras like they're infallible, but you do have the right to request the device's Home Office type approval and a valid, current, up-to-date calibration certificate for the camera. If the prosecution can't produce a valid calibration certificate stating that the camera was indeed calibrated and passed inspection on the date in question, then obviously their primary evidence collapses. But in fairness, this does go much deeper than just one uncalibrated camera. Recently, the facade of infallible cameras and modern technology completely crumbled. In January of 2026, this year, the Department for Transport was forced to launch an investigation into a massive technological failure on 3 main roads that involved 154 cameras that potentially issued thousands of speeding tickets incorrectly. National Highways confirmed around 2,600 erroneous activations going back to 2021. So, If you receive a speeding ticket, scrutinise it. Don't just blindly accept it. The state's technology has a proven documented record of catastrophic failure. There's a card up on the screen now with a link to a video about the actual failure of those cameras, listing the roads it happened on and more details should you wish to watch that and use that information for grounds to fight a ticket. The burden of proof is on them to prove that their equipment was functioning flawlessly when your ticket was issued, and as has been proven, that's not always the case. So option 5, technical failure, is a good place to start. I do have a bonus tip if you've got a speeding ticket and you're concerned you might lose your licence. It's a Hail Mary, but it's referred to as Section 35 Exceptional Hardship Clause. So what happens if you try any one of these defences and they fail, and you've hit 12 penalty points, so you know when they're issued in the court you're going to lose your licence. As normally, under the Road Traffic Act, hitting 12 points does mean a driving ban. 6 points if you're a new driver within 2 years of passing your test. But Section 35 of the Road Traffic Act does contain the exceptional hardship argument. Now the court accepts that you losing your licence may cause you to lose your job. It may cause you hardship. To be fair, that is the point of the actual punishment. But if you can prove that losing your licence and being disqualified will cause exceptional hardship to a third party, the magistrates do have the discretion whereby they can let you keep your licence with 12 points on it. Again, like I said, this is a Hail Mary pass, there's no guarantee. But if you're a business owner and you'd have to lay off staff if you lose your licence, or if you're the sole carer for a disabled person that lives in the middle of nowhere, or if somebody completely relies on you for their mobility, you may have a successful argument for exceptional hardship. So you can present that in mitigation in the hope for leniency. So again, although you'll be pleading guilty, you'll acknowledge the fact that you were speeding. You're basically going to ask the court to be lenient based on somebody else relying on you as a driver. Again, no guarantee it'll work. And you can't just say it though. You would have to come to court armed with proof, medical letters, employment contracts, any relevant records of proof, or even statements from people that you help. Then you might have a chance. So, as a last resort, if you can pull out of the bag proof of third-party suffering, it might just keep you on the road. So, these traffic cameras are not infallible, and state technology isn't scrutinised enough, we know that, and automatic justice is inherently flawed, but you do have rights under English law. So bear in mind these 5 possible reasons that you could use to argue your speeding ticket. Scrutinise the dates, check the signage, request the calibration records, know the difference between duress and special reasons, and don't let blind faith and a broken system cost you your licence. If you found this breakdown empowering, hit subscribe for more rigorous investigations and explanations into your legal rights. Share it to a friend, but most of all, stand your ground, stay informed and drive safe. Until next time, thanks for watching.